So, Kevin.
Yes, Rebecca.
Here we are in the readathon.
Another Karen readathon.
That's right, and we have two very big developments today.
Mm-hmm.
What is today's date?
Today's the 23rd of August?
Yes, today, Friday, August 23rd, Judge Beverly Cannoni issued her ruling on that August 9th hearing, that motion on the August 9th hearing to dismiss the charges against Karen Read, those two charges that 5 jury members have come forward now and said, remember that they had decided they were not guilty on charges 1 and 3. Karen Read's team came to court and said, even though a mistrial was declared, the jury never got a chance to say those things. And so they wanted there to be those charges to be dismissed because it would be a double jeopardy situation. All they asked the judge to do was bring in those jurors and ask them, right? So Judge Beverly Cannoni has issued her ruling. She has denied the ruling to dismiss both the charges. Basically, what she says is, in the ruling, is that because the defendant was not acquitted of any charges and defense counsel consented to the court's declaration of a mistrial, double jeopardy is not implicated by retrial of the defendant, and the motion is denied. She also referenced conversations in the courtroom during jury deliberations when the jury came back in with a note to the court indicating they were at an impasse. David Yannetti, that's Reed's attorney, argued that they should be given that Tui Rodriguez instruction, that dynamite instruction. And because attorney Yannetti argued twice for that instruction, Cannoni said it consented to a mistrial. So that's the sort of crux of her argument. And that the state law is that it must be said in open court, that the jury must say in open court that they acquitted her on those two charges. So that is the state law. Karen Read's new lawyer, Weinberg,
the appellate lawyer,
has said to WBZ News that he respectfully but strongly disagrees with the cornerstones of today's ruling and fully intends a vigorous appeal to assert and uphold Miss Read's rights. Under the double jeopardy clause. And of course, the state spokesperson David Traub says, we believe the judge's decision is consistent with 200 years of case law. We're moving forward with trying this case on January 27th.
Yeah.
Thoughts? Yeah,
second part first. I'm not surprised that they're going to appeal it to a higher court. And first part first. First part second. I'm not really surprised that the judge decided to go this way. I think a lot of this actually is not, based on existing case law as far as, it needed to be an open court. I really feel this comes down to the judge's mistake.
Yep.
So as far as saying, the law, you interpreted the law this way, or it should be, just bring them in and talk to them. Bringing them in and talking to them doesn't seem like a big stretch. Is the motion really to dismiss, or is the motion...
The motion was to dismiss, but what the lawyers were asking her to do was to just ask the jury and then decide to dismiss. I mean, they couldn't put in a motion to say, hey, ask the jury. The motion was to dismiss, but then in court, Weinberg said, all we're asking you to do is talk to the jury, implying, by the way, if you talk to them, that you'll then decide to dismiss.
Right. You'll see that they're, again, the way I see it, and unless the law is different, it certainly seems like she heard we're deadlocked and just said we're done and didn't do the other things that she normally should have done.
Right.
Which is she presumed they were deadlocked on all charges when they were deadlocked on one and had come to a decision on 2 others.
Right.
So I feel like the fault here doesn't lie with the jurors and the way they communicated. It doesn't fall on the defense that you had an opportunity to argue against that and that they didn't take it. It really seems like the judge did not do her due diligence and simply just assumed that there was no agreement on any charge.
Yeah.
Because, I think we all would agree that if they came out and they said, Your Honor, we have, reached verdicts on 2 charges, we're deadlocked on 1.
Yeah.
How should we proceed?
Right.
The judge would have said, "Well, come back with your two verdicts, and if you're deadlocked on 1, I'll declare a mistrial on that charge."
Right.
And now, do I believe 100% with my heart that if the defense knew that there were verdicts on there were verdicts on 2 charges, but they had, they had a chance to just declare a mistrial and walk out of court, that they wouldn't have taken that. They would have said, no, let's roll the dice and see what the jury comes back. Probably not.
I agree.
Because in the moment, they're like, that's a win.
Yeah, I think a mistrial was a huge win.
Yeah, mistrial altogether is, and it isn't until later they said, oh, wow, maybe if we had gone behind door number 2.
Because the one that they could have agreed on could have been the murder
Exactly,
one.
right.
It could have been the second degree murder.
Right. They could have found her, they could have found her guilty on any of these charges, and that would have been a loss. So yeah, walking out of court is still a win. But knowing what they know now, obviously it's like, well, we feel like you made a mistake. And as far as the mistake being made, I think it's the judges, because just as sort of a so that makes it hard to appeal to the judge.
Right.
You can't come at the judge really hard saying, Your Honor, you messed this up.
Yeah.
Right. But you can say that to an appellate court.
Right. And that's what explains Marty Weinberg's affect in the dismissal hearing. Like, he was so deferential to Beverly Cannoni, and she was really listening to him, and you could tell. I mean, he came at it with a real sense of respect and saying, like, of course, Lolly had good reason to not return these calls, and of course you didn't mean, how would you have known? You didn't mean to make this mistake. But in fact,
I don't think he even addressed anything that the judge did.
No, he did.
Oh,
he said you couldn't have known.
You couldn't have known.
He basically.
Wait, you couldn't have known. You obviously could have known. No, you could have. You asked.
He basically said, like, a lot of it's not your fault stuff, and then said, but now we have an opportunity to find out. It was sort of in that tone.
Yeah.
Right.
And I think probably some of this will hinge on the state law about it's got to be read in open court.
Right. I still don't think it's a winner personally, because I agree with you that it probably wouldn't have changed the outcome of what the defense would have decided to do. And if a judge is a former lawyer, they will know that. Right?
Yeah. Judge is a former defense attorney. Yeah.
Right. So I have another piece of big news.
All right.
Turtle Boy today published an interview that he did with a juror.
Okay, no, I thought that was on and it was off, and
it's on and it's an anonymous interview.
Okay.
However, he says in his article that he was very skeptical when he was approached by this juror, and that he was very worried that it was somebody, pretending.
A false flag. Yeah.
Someone like from the McAlbert camp or anti-Karen.
Yeah.
So he asked them to describe themselves. They did. And then, of course, he realized that, some of the anti-Karen people were also in court and they would be able to describe a juror.
Yeah.
The person offered to get on video with him. And next thing he knew, he was looking at a juror that he had seen in open court.
Yep.
So the jurors said that they would answer questions in writing. So he sent the juror 40 questions. And the juror answered most of them, but not all of them. And would you like to hear some of the most interesting takeaways?
Sure.
But first, I'm going to tell you the questions that the juror did not answer, because you might have questions related to those. So, you might have follow-ups, and, this will tell you why. Okay. One question the juror did not answer. Would you ever consider coming forward and using your real name? Juror won't commit. Are you in contact with other jurors in the case? Juror doesn't want to talk about other jurors at this time.
Okay.
Do you know why the juror in red was eliminated? Juror doesn't want to talk about other jurors at this time. What sort of questions did Lolly and the defense ask you during voir dire? Juror is worried this will lead to identifiable information.
Okay.
Did your family and friends know you were a juror? Did they ask you about it? How hard was it to keep your identity a secret? Juror is worried this will lead to identifiable information. Do you understand the Jen McCabe Google search testimony from the 3 witnesses? Which did you find compelling and why? No answer. Do you believe Karen Reed killed John O'Keefe with her car? Juror is worried this will lead to identifiable information.
Really? Okay. All right.
Has this case changed your attitude and trust toward the police? No answer.
Okay.
There is one huge, well, there are a couple huge takeaways in this interview, but there is one very big takeaway in this interview. You ready?
I'm ready, yeah.
Okay. Did the jury have any feelings about the federal investigation? If not, what did you think Ryan Nagel was talking about when he said he spoke to the feds? What did you think all the references to, quote, other proceedings witnesses testified at were in reference to?
Okay, yeah.
This is the answer. Perhaps others caught on, but I honestly had no idea. I missed Ryan Nagel mentioning the feds during his testimony, and I assumed the other proceedings was another grand jury or something like that. I had no reason to think there was something as big as a federal investigation going on outside of the trial. Next question. Do you feel deceived about not being told about the feds? I don't think that I would use the word deceived, but I would say misled. Looking back, not knowing the entire scope of what was happening and not having what seemed to be crucial information likely hindered my ability to see the whole picture. If I had known the full scope, the ARCA witnesses would have made more sense. The things I thought were important may not have been where I focused my attention, and I may have looked at some witness testimony differently. Next question. How could anyone on that jury think that Karen Reed hit John with her car after hearing from the ARCA guys? Ready for this?
Yeah.
I can only speak for myself, but you have to understand that we were not told where these witnesses came from. There was a lot of conflicting testimony throughout the trial, specifically regarding IT and accident reconstruction experts. I understood that neither the Commonwealth nor the defense hired them, but I had no idea where they came from. For all I knew, they were two very smart and well-educated people who read about the case online and decided to analyze what happened. I found them credible, but there were things they weren't aware of that I thought were important, and I couldn't understand why they were testifying when they didn't seem to have all the information. The positioning of their presence and the information they seemed to have been provided to analyze was strange, but being hired by the FBI or other agency never crossed my mind.
Yeah, and it's not, yeah. Of course, that was the decision of the judge to not permit the jury to know about the federal investigation into the investigation, although allowing the defense to use the information gleaned from that federal grand jury investigation.
Correct.
And it sounds to me, and I think we're all picking this up, that if they had known that there was a federal investigation into it, it would have changed the way that they viewed a lot of that. Certainly, it would have changed the way they viewed the expert witnesses for the defense.
Hasn't it changed the way you feel about this case?
Oh yeah, 100%.
From the beginning, right?
From the beginning, the idea that investigation was there, and they seem to be focusing on that. I mean, yes, 100%. That changes my view of everything about the credibility of the alternative theory of the case.
Right. Also, knowing where the witnesses came from is actually very freaking important.
Yeah.
Knowing that.
But I think it's more what I'm picking up here is not knowing where they came from was important. Yeah, it was influential that they're kind of like, I'm going to say they discounted, they would have put more weight on what they were saying had they known somebody like the federal government, the FBI had called them in, and that's why they were coming in, because it sounds like one of her interpretations might have been, these were armchair detectives who had good theories and just came forward and said, here's what I think.
All right, so you want to hear some more juicy stuff?
Yeah.
There's another big takeaway, and there's actually a few big takeaways, but the other one that I think is really big is the presence of Brian Albert in the courtroom during closing arguments.
Right. Okay. He's the homeowner?
Correct.
All right.
How did you feel about Brian Albert being in court for closing deliberations was the question. Of course, closing arguments is, I think, what he means.
And can I just get for clarification, did Brian testify?
Yes.
So he was known to the jury. Okay.
Yes, they knew who he was.
Okay, and he came back. All right.
So,
and didn't he position himself in the courtroom directly across?
The jury. He was sitting with the O'Keefes and Jen McCabe, looking at the jury. Right.
Because if you can envision the courtroom, it's more like a shape of a U.
Correct.
Where you always see the jury on the side, and there was seating opposite them on the side, so people could look not from behind but directly across from each other. Okay.
Right. So
what did that mean?
How do you feel about Brian Albert being in court for closing? I felt it was inappropriate. He was a key witness and a major focal point during the trial, so I don't think he should have been allowed in the courtroom at any time other than his testimony. That goes for Jennifer McCabe and Colin Albert as well.
Yeah, that's generally a thing that does happen. I'm trying to think that he probably, under most circumstances, wouldn't be allowed to come in while there was testimony still ongoing. because, they're not supposed to know what other people are saying, and that perhaps the argument is like, yeah, well, there's no further testimony as far as he, cannot be influenced and change his testimony based on what's happening at this point, so it's okay for him to be in without giving consideration to what the juror says is that now him coming back and where he's positioning. She doesn't say necessarily that she was intimidated by him.
I don't know it's a she.
Oh, yeah, okay, yeah. Why do I assume it's a she?
I don't know.
They don't. I don't know. Just because I think women are more likely to stand up for the right thing instead of a bunch of goofy guys.
Oh, what a good answer.
Yeah, I don't know. That's like literally what's in my head. But this juror, they say like they just feel like that was not appropriate.
Yeah.
Okay.
Here's another question. Are you ready?
Mm-hmm.
Did you feel deceived by the inverted Sally Port video?
Oh, okay. Yeah.
This is juicy, right?
These are great questions, by the way. Yeah.
Yes, very much so. The prosecution's emphasis on this video and its supposed significance in proving beyond a reasonable doubt that nobody was near the damaged taillight was a primary focus throughout the trial. It was a shock to find out what I believed was seeing and what I was actually seeing were not one and the same.
Perry Mason moment, yeah.
Right. This is interesting.
Mm-hmm.
By the way, I'm not reading these in order. I'm just reading the things I think are interesting. Do you believe Katie McLaughlin's testimony that Karen Reed said I hit him at the scene that morning? Do you know who Katie McLaughlin is? Do you remember?
Is that the EMT? Yeah.
EMT.
Who has, what did I say?
Yeah, that's what you said, yeah.
That's EMT. It is AMT.
Yeah, EMT.
ATM. Who also has familiar their relations.
She's like best friends with one of the Alberts.
Yeah, okay, that's it. Yeah.
I actually really like this answer because it's right in line with what I think.
Mm-hmm.
I believe Katie McLaughlin believes she heard this, whether from her own memory or what she was reminded she heard.
Okay.
Which is actually what I think. I think she believes she heard. I think she was told she heard it, and she thinks she heard it.
So
However,
she's not being deceitful in what she's saying, although she may not be accurate.
Right.
Okay.
However, I did find it hard to believe that all the first responders on the scene that morning, she was the only one to hear that statement. But at the same time, there was a lot of conflicting testimony from first responders of what they heard or saw. I didn't put any more weight on this testimony than other testimony related to what people heard or saw that morning.
Okay, cool. Yeah.
All right, you ready?
Yeah.
Did you find Colin Albert's testimony believable?
Oh, big question. Big question. Okay.
You're going to like this.
Mm-hmm.
I found Colin to be purposely elusive when asked questions he was prepared for. But when it came to questions he was not prepared for, the cracks in his testimony started to show. I think we can all agree that none of us has ever slipped on ice while holding a solo cup and broken our fall with just our knuckles.
Yeah. Yeah, man. 100%. 100%.
Yeah. Did you believe Colin Albert was inside Brian Albert's house? I know that at some point Colin Albert was inside the house. That was proven beyond a reasonable doubt. But whether he was there past the time he stated is not as clear. I do put weight on Allie McCabe seeming to slip up during the part of her testimony where she stated that Colin wasn't in the house when John was. I could believe that is the truth, but the statement also put John in the house, which is something the Commonwealth has said did not happen.
Yes, exactly. That was the big slip up.
Yep.
Not that they're focusing on Colin. No, Colin wasn't there saving Colin. John was there at a different time. Oops.
Right.
Okay, yeah.
What did you think of Jennifer McCabe's testimony? I found Jennifer McCabe to be combative, which was off-putting. Her demeanor made it difficult to process anything she was saying. Something felt off when she continued to ask to be reminded of statements, events, etc. with evidence of her prior accounts. It felt like she needed reminders of what she had previously said before she answered to keep from contradicting herself. Yeah. Do you find Brian Albert's story believable about not waking up to come outside?
Okay.
I was very torn on this. On the one hand, I can understand being drunk, going to bed late, and being deep asleep to the point where nothing wakes you up. But I also find it hard to believe that a first responder's instincts, which are ingrained and become part of who they are over the course of their career, had this much commotion on this front lawn, and those instincts didn't kick in at any point.
I just think a regular homeowner would just be curious enough.
Yeah. Another Brian Albert.
No one went in to wake him either.
No.
Yeah.
Well, remember though, his wife also did get that phone call from her sister outside that she did answer. So they were awake.
Yeah, I know. I'm just poking at the story.
Another Brian question. Brian Albert, Brian Higgins, and Michael Proctor all greeted the jury and thanked them after their testimony. What did you think about that?
Say that again? I don't think I knew that.
Yeah.
Say that again?
They all greeted the jury and thanked them after their testimony. Brian Albert, Brian Higgins, and Michael Proctor.
Okay.
These three men were a huge focal point of the trial, so while I wish I could have taken it as nothing more than a polite gesture, I did not. Yeah. Which witness did you find the most compelling? The medical examiner. She was a straight shooter and gave her medical opinion based only on the facts. There was no point where I felt her opinion had been influenced either by the Commonwealth or the defense to fit a theory being presented. I felt the same way.
Yeah, that's good. Okay, sure.
I really like the medical examiner. At one point, the juror says that they do feel that there was some bias against the defense, particularly Mr. Jackson by Judge Cannoni. That for the most part, Judge Cannoni was very kind to the jury, made a point to remind them to stand and stretch, was, kept timing and schedule like clockwork, reminded everyone to keep their voices up, etc.
She seemed very, she seemed very protective of the jury, and that seems to be one of the reasons why she was so quick to let him go.
But at times, there was a level of professionalism that wasn't being maintained, and that the severity of the circumstances was not always at the forefront. It bothered me when there was an objection and the response was, I'll let them have it. I think there was some bias against the defense, particularly Mr. Jackson. But then they also say that they think that she was hard on Mr. Lally. Occasionally, there were times I would glance over and wonder if she was paying attention, etc.
Good feedback, Judge.
Yeah. Were you made aware that jurors would not be receiving transcripts and would have to rely on their notes? Yes, we were told at the beginning. The jurors.
Some states don't allow that, particularly for the reason that people get attached.
No, I know.
To what their notes are.
Oh, also, so question about the juror. Did the jurors see the protesters outside? They said that there were times they could hear it a little bit, but it is not really a factor. They could not see the protesters outside. So basically those were to me the biggest takeaways from the questions. A lot of the questions were very processed.
Was there any questions about their impression of Karen Reed herself?
No impression of Karen Reed. Oh, there was a question about sort of the everybody being in court. And the juror did say that they felt very bad for both the O'Keeffes and the Reeds. There's a lot of empathy for both the O'Keeffes and the Reeds, and there was definitely a sense of sadness for both families, and not one side or the other side.
Yeah.
So, and also this juror said that they believe that Turtle Boy is rough around the edges, but genuinely seems to care about the truth in this case, which is why they reached out to Turtle Boy.
Is that a question? What do you feel about Turtle Boy?
Let's see. The question was, why did you decide to speak with Turtle Boy of all media outlets?
Yeah.
That's a good question.
It's a good question.
I have that
it's
question,
a fair
don't you?
It's a candid question for Turtle Boy to ask.
Exactly. It is a very candid. Also, it's like a good question to be like, Turtle Boy is very problematic in many ways. He does have anti-trans stuff on his blog. He does have a lot of objectionable things on his blog. And I would also consider, very honestly, going to him if there was something I really wanted to get out there.
Yeah,
because
this case,
he will vet it and put it out there. Oh, so that question about empathy came from, what did you think of John's mother crying during the trial? And the juror said that they had intense empathy for both the O'Keeffes and the Reeds. The most pointless witness, they said, were the two women that were in Aruba with John and Karen. And the most unnecessary witness, they said, were John's niece and nephew. There was no reason for them to testify. It was just like their kids had been through enough and they didn't add anything to the testimony. Did you believe Lucky Loughran's testimony?
The plow driver, Lucky.
Lucky was a likable man, as is his boss, Michael Trotta. Lucky's testimony appeared to be truthful. It didn't seem he had an agenda, but that he just wanted to share what he knew.
Yeah.
I have the same impression, don't you?
Yeah.
How long did it take the jury to reach a unanimous not guilty verdict? And the juror basically says, given that the motions remain outstanding, I don't want to answer that. Basically, the juror says that given that things are outstanding, they just want to, which is fair.
Yeah. Again, I would think like the nature of the jury deliberations are things that aren't usually they're supposed to say.
Right.
I mean, they can talk about themselves, whatever, but they aren't supposed to talk about, like, if they're quizzed by lawyers later, they're not supposed to ask them about, like, well, how did this go? How did that go when you were talking about it? Yeah.
Now that you've had time to research the case, post-trial, what have been some of the most surprising things to learn about? What do you think was the most surprising thing to learn about?
Well, I think the federal grand jury.
Hell yeah.
Yeah.
The federal investigation was a huge surprise. A lot of things made more sense after learning that.
Oh.
They also were surprised how much it had taken over social media, podcasts, etc. Final question. You ready?
Yeah.
Do you think Chloe is alive?
The dog? Oh, God. Jesus.
Answer, I hope so.
Oh, I hope so.
Yeah.
God damn.
Yeah.
Wow, that is really interesting stuff.
It is. This is, okay, so.
There's some good takeaways for the judge the prosecution and the defense.
Abso-fucking-lutely.
Because, I mean, certainly if I were the judge, if listening to this, I would, again, the notes about the judge's demeanor towards the defense, that's certainly read. Yeah, I mean, I think the prosecution can really learn here about how we already know the defects as far as Proctor being a witness in the next trial, but also they certainly see what they have just seen. The prosecution has just seen what this jury found surprising about their witnesses, and now they have a time to prep them.
Right.
For those, like, what questions really landed? This one, because they didn't have an answer. We're going to prep them next time so they don't mess up again.
There's one other thing.
What's that?
I think there is strong, and I don't know like how much they can actually use this, like an emotion or whatever. Mm-hmm. Certainly, if there's another trial, which I still am not 100 that there's going to be another trial.
Be, but yeah.
They're going to fight again to try to get the federal stuff in.
Oh, yeah.
And certainly with at least one juror, and I really hope more come forward and say something similar, with at least one juror saying that they were absolutely upset by the fact that this was held from them. Mm-hmm. And it completely skewed them, like not knowing where a witness came from or why they were there.
Yep.
Made the testimony less valuable. That's important information.
Yeah.
And if, I know they're not supposed to talk about their deliberative process and their thinking, but like I would fight a lot fucking harder. And I know they fought hard, but I'd fight even harder to get it in next time, or at least be able to fight to frame it differently than, quote, another proceeding.
Yeah.
I don't know how they're going to be able to do it, but I would try.
Well, I mean, I think the way that they have to find some way to sort of telegraph the importance of that proceeding, that it wasn't just sort of another thing.
Right.
Right? Without saying it was a federal grand jury, did you say in another proceeding? In another, right. In a particular proceeding. In a particular, I mean, there's got to be a way to start leaning on that so they ask more questions about what was that proceeding?
Right.
As opposed to like, okay, that's the place where this came from was a different proceeding.
Absolutely.
And that, because it sounds like they assumed that this was a proceeding around this case as far as this prosecution, this defense.
Another grand jury, they said.
This is I'm going to say third party, but this is a completely set by separate parties looking into this, coming up with other information.
Keep in mind that what they had heard, they weren't supposed to hear it, but they did because of the prosecutor's questioning. One thing that they heard that they weren't supposed to hear was that Lucky Loughran was interviewed by a PI for the defense.
Right, okay.
They weren't supposed to hear that. And Lolly got it in there on purpose, and then it was stricken from the quote record. But they did hear that the defense investigator had interviewed Lucky Loughran, and that was the first time he had told his story, right? And it was like, were you approached by a man named Paul who blah, blah, blah. And then it turned out that was a defense investigator. The jury heard that, even though it was supposed to be, they were supposed to disregard it, right?
Yeah.
They had no reason to believe after hearing that when these two guys showed up and it was like, did I hire you? No. Did they hire you? No. Like, of course, if not knowing anything, I would also be like, oh, this is probably somebody else's investigator. This is some other thing. You know what I mean? Maybe this is some TV show that hired a PI. It could be the Discovery Channel.
Right.
Hiring a PI to make a movie.
Right. It shows that for this juror, the provenance of who these witnesses were, where they came from, meant a lot to the credibility about what they said. They certainly took or would have taken what was said with greater weight or less weight if they knew where they were coming from. So if they knew that, it certainly seems like the federal grand jury, carries a lot of weight. I guess that decision was made by Judge Cannoni, and so in trial 2, is probably not going to change her mind on that and revisit it. So they just have to know that there's got to be ways to. You probably can't get in what it is, but you certainly can continue to flag that this is something they need to think about and let them draw their own conclusion about what this is.
Right. Turtle Boy says in his takeaways that jurors believed that the ARCA guys could have been hired by Karen Reed's insurance company. which is not like a bad assumption to make. Like,
Yeah.
okay, so the juror missed Ryan. These are Turtle Boy's takeaways. The juror missed Ryan Nagel accidentally mentioning the feds. The medical examiner was supposed to be a strong witness for the Commonwealth, but ended up being a strong witness for the defense. The juror clearly felt intimidated by Higgins, Albert, and Proctor. Considering the Sullivan sisters and the kids were only called as witnesses to prove that Karen had motive, it wasn't surprising that the juror found them the least relevant witnesses. The fact that the juror reached out to me, he says, and was the first juror to talk about their experiences speaks volumes about how I am perceived by the general public and should help me with my bogus witness intimidation charges.
That's right.
Aiden. Anyway, so that's what's happening
Fascinating.
today. Fascinating developments. This is why, it's funny. I personally am just so like turned off by so much of Aiden Carney's like politics and thinking and previous writing and so forth. But it is really snobby and disingenuous to say that the dude is not a journalist. It really is. This is, the questions that he asked, the fact that a source came to him, and the fact that he's like vetted the source, like he does the journalism. He does.
Yep.
And I was talking to somebody at the podcast conference we were just at, who I won't name, who works for a media outlet that, shall we say, could and should be covering this case better than they are, and agreed with me that a part of the reason why New England media outlets are not doing the best job covering this case is because a lot of the snobbery around Turtle Boy's coverage. It's sort of like,
and don't forget true crime. Well, this is true crime.
The true
nose turn.
But what this person said and agreed with me on is that this is much bigger than a true crime story.
Oh, yeah.
This is a public, official scandal story. This is a malfeasance story. This is a betrayal of the public trust story. This is a police and prosecutorial misconduct story. Like there's so much more here, and the way it overlaps with the Sandra Birchmore case. God, let's hope they don't drop the ball on that one. The media,
Yeah.
Let's hope if Turtle Boy picks up on that like big time, that they don't choose to drop that just because he's doing it.
Yeah.
You know what I mean?
Yeah.
And by the way, this person did tell me that his coverage of it is a big part of the reason why their outlet is like, we don't want to be seen as conspiratorial, but whatever. But the reporters
why don't you be seen as journalists?
But the reporters there believe that Karen Reed didn't do it.
Yeah, great. Helpful.
I know, very fucking helpful, right? It would be nice if they did some stories and did some reporting that bore that out. Anyway, yeah, so I'm going to leave it there for today, and we will be back because something tells me, and this is just a hunch, just a hunch, just a hunch, because my experience tells me that when a person comes forward, others follow. Isn't that what your experience tells you?
Yeah, it has. Well, we started with one nameless juror, and we've gotten to 5.
Yes.
I feel like one more of those 5 might come forward.
Yes, and this is obviously different context, but for those listeners who may have checked out the podcast, The 13th Step, that started out intentionally as a radio and print story, like a year and a half before, intentionally. A source had come forward. Lauren did a bunch of reporting, put the story out there in a world in a much smaller way, on purpose, so to entice more sources, to have more sources feel safe coming forward. And that's exactly what happened. So, Eric Spofford was outed. And by the way, Turtle Boy also had done some reporting on Eric Spofford.
Oh, wow, yeah.
Yeah. Anyway, all right, so I'll leave it there.
The streams keep crossing.
The streams keep crossing. I will leave it there for today, and I'm so happy that we're back in the studio for another readathon. Let's see what happens next.
Got it.
Thanks, Kevin.
Partners in Crime Media.